My presupposition will be that judicial independence is never fully completed. It is always in the making. To put it differently, judicial independence is never to be taken for granted. It is never reached. It is never complete. But it always has to be defended. There are always risks, threats, challenges. So one has to be alert. Even in a, say, when you have an established rechtsstaat, rule of law, like for example Germany or the United States or France, where judicial independence is one of the core values of the judiciary, it is never a completed achievement. It's always in development, and it always has to be guarded. And of course, it has to be guarded by justices and judges in the first place. Not only by that. That is my presupposition. First, a preliminary remark. It's judicial independence is one of the core values of the judiciary. And to explain this, I can refer to an inventarization that has been made recently in the Netherlands of the core values of the judiciary. And this inventarization has been made by the Dutch Association of Judges. And it has been based on several sources. It has been based on the Bangalore principles of judicial conduct. I'm sure you're familiar with that. Also on the English Guide of Judicial Conduct. The ENCG Working Group on Judicial Ethics. ENCG means the European Network of Councils for the Judiciary. And the second source is from France. It is a report, the Commission éthique de la magistrature. So on the basis of these four sources, an inventarization has been made of the core values of the judiciary. And this inventarization has resulted in 8 core values. And perhaps it's an idea to put them on the whiteboard. I wanted to say, use the old-fashioned word blackboard, but blackboards are white nowadays. Whiteboard. And the first one, it shall not be a surprise, is independence. Independence is the first and most important core value of the judiciary. The second one is closely connected. It's called autonomy. Perhaps we can explain them later on, and now I'd like to give first an inventarization. The third one is impartiality. Which is, as you know, closely connected to independence and autonomy, but it's not quite the same. The fourth one is competence and diligence. The fifth one is propriety. Proper behavior. And what is proper behavior is, of course, very much dependent on the context, time, place. The sixth one is social involvement and public responsibility. integrity. And the eighth one, I would say last but not least, is justice. This is the inventarization that the Dutch Association of Judges has made. Now what's interesting is that in the whole discussion on judicial ethics in Europe nowadays is focused on core values. It's not focused on rules of proper behavior anymore. If you look into the old codes, the codes of conduct, you see all kinds of rules for proper behavior. What justices and judges should do and should not do. Very specific rules. But nowadays, there's a different approach. And the approach focuses on values, much more than rules of conduct. And one can guess what's the reason for that. Values, of course, are more abstract, but they have to be interpreted for different circumstances. Because what does it mean, proper behavior, in different contexts? And there can be all kinds of discussions about it, and it can raise all kinds of dilemmas, of course. And what does integrity mean? Of course, the core of integrity we understand. There are all kinds of shady questions about what integrity is or not. Let alone justice. What does justice bring? Demand. What it doesn't demand. It was not my intention this morning to give a lecture on these 8 core values. I wanted to focus on independence, but if this list of values raises any questions, please feel free to ask. Is there any question about this? Is it in some way, is it coherent with what is regarded here in Indonesia as the core values of the judiciary?
The fifth
propriety, which is the proper behavior, both in court proceedings as well as in private life. In court proceedings, for example, the proper approach of people in court, of the defendant, of the lawyer, of the public prosecutor, how you approach them as a judge, how you ask questions, how you can listen, how you not bully them, but be open-minded in your approach. Try to focus and listen on the content of what they say and not the way they say it. And that is the proper behavior in courtroom. But it also refers to the proper behavior outside your professional life. And there's a discussion in the Netherlands, for example, whether when you are a justice, whether that raises restrictions also for your behavior in private life. What can I do as a judge, as a justice of the Supreme Court? Can I do in my free time the same as any other citizen can do, or am I restricted in some way? Does my behavior has to be an example, or should we see that differently? And there are differences of opinion in the Netherlands on this. And some people say, well, in private life you're anonymous and you can act as anyone else. But there are also judges who say, no, you are a judge 24 hours a day. And it's also in private life, you have to be a role model. So there's a difference of opinion. How is that here in Indonesia? How is that regarded? Is that the last opinion?
The same.
The same.
Maybe.
Yeah. 24 hours.
Some.
Yeah. That's also my opinion. It's also my opinion. Very surprising. Yeah.
Professor, I would like to know more about the context behind the inventarization of these core values in Dutch, in the Netherlands. When was actually the inventarization made?
Very recently it was done, and it's based on a comparison of the codes that I mentioned. And what they did was not so much focus on the rules of conduct, but they tried to abstract the values that were behind the rules. And they came to this inventarization of eight core values. Of course, you can come to another inventarization. There's always something arbitrary in this. But when you compare them, you see, well, something arbitrary, but the core is the same. It's always the same values. It's always about integrity, justice, independence, impartiality. They always return in each list. But this is a very recent one.
Was there any political momentum or something which then made the judges in Dutch Judges Association to do this kind of initiative, and whether this is regarded as something like a regular initiative, so that those values can be revisited by the judges from time to time?
That's a very interesting question. You know, until recently, we didn't have any code of ethics for the judges in the Netherlands. And what happened was when Dutch judges went abroad, for example, they went to the new democracies in the eastern part of Europe, the colleagues always asked, what is your conduct? Where is it? Is it translated? Can we read it? We say, oh no, we don't have a code of conduct. No, why not? Well, we do not need it. Oh, no, why do we not need it? Is everyone okay? Is there never any wrong behavior? Is there never any infringement of any rule? Well, no, but we know what the core values are. So, and that was not a very satisfactory situation. So some years ago, they first started with a guideline on impartiality. So what does it demand? Impartiality. And this was just one of the values, of course, and it was translated in a certain amount of rules of conduct. But they were much more, they were too specific, and they were not very informative. For example, you can't decide a case where one of the parties is your nephew. Yeah, okay, we know that, so it's not very informative. So they try to improve by more abstracting to the level of the core value. So this is a process in the making. It's not been formally established yet, but this is the state of the art nowadays in the Netherlands as regards to the written judicial ethics. And it is in conformity with developments in other Western European countries, as I mentioned before. Yes, please.
Can I ask more about point 4, the competence and abilities?
Yes.
Could you talk a little bit more about what you mean by competence?
Competence is craftsmanship. It's craftsmanship. Know your profession, know how to exercise your profession, but also be responsible for keeping your knowledge and expertise up to date. Also, you are responsible as a judge. You see that in several codes, you are responsible for your expertise, that it is not outdated, that you study new developments in international law, in European law, in national law, that you keep your expertise up to date. That's what meant by competence.
So for example, if in a case a judge applied the wrong law or incorrectly applied a principle of law, that technically would be a a violation or an issue that should be raised under the code?
Not necessarily. I mean, I always try to make a distinction between mistakes in exercising your craftsmanship and in faults in shortages in integrity. I mean, not every fault in judicial fault is immoral behavior. I mean, there's a difference between craftsmanship and the morality of the exercise of your craft, and we shouldn't mix them up. It's not always the case that when a judge makes a mistake, it happens. I mean, they are humans, human beings after all. So it happens, and we have provisions for that. We have appeal and we have cassation, so there are mechanisms for the correction of mistakes. And it is not always an infringement of a code of ethics or a rule of professional morals. I think we should separate the two categories. I'm sure there are cases where you can hesitate. For example, when there are very clear professional failures, evidence failures, to the advantage of, for example, someone known to the judge. Then you are on the border of a professional mistake and a moral mistake. But in principle, there are two different categories, I would say.
So could it then, for example, be an indication that there might be a moral issue? And so if you, for example, saw that there had been an error in the application of law, it might be a reason to perhaps consider whether one of the other 7 issues have been violated, for example?
Yes, well, again, let me give you an example. We have in Dutch law, we have an instrument for parties if they think that the judge is not impartial. The parties can apply to a recusal of the judge. And what happens then is that other judges step in and they judge the impartiality of the presiding judge. Now this was intended to be an instrument for the exceptional cases where a judge showed himself to be not impartial. But what happens nowadays, in a lot of criminal cases, but I look to my colleague, the experts in this field, is that you see that the instrument of recusal is used any time when a judge takes a decision that is not favorable for the party involved. But not any unpopular decision is a violation of the value of impartiality. So impartiality is only the obvious bias of a judge, or the case that one of the parties has good reason to doubt the impartiality of the judge in question. And that is not always the case when the judge makes an unpopular decision. So one last question on this list, because otherwise I would like to focus on independence. That's what I promised you after all. Yes.
You previously mentioned about that in the Netherlands there is no growth of case. Am I correct in assuming that in the Netherlands so there is no clear reward and punishment system? Because
for judges, a disciplinary system. You mean?
Oh, you have the.
There is a disciplinary system. There is a disciplinary system, and there are, roughly speaking, 2 possibilities. If a judge makes a serious mistake, for example, commits a crime, then it is up to the Procurator General to interfere and to put the case before the Hoge Raad. And the Hoge Raad has a fourth chamber, and the fourth chamber is has disciplinary authority. And the judge can be suspended or he even can be fired. So that is for the serious cases. And for the less serious cases, parties can complain about the behavior of the judge at the president of the court. The president addresses the complaint.
Yes.
Those are the two, roughly speaking, disciplinary mechanisms.
So are there any set of written rules?
So, written rules for that? No, except for the fact that judges have to apply as any other citizen, of course, to criminal code and other laws. But there are no especially written rules for judges in that respect. So this code, for example, when it is elaborated, could be a source for disciplinary actions and for disciplinary sanction. But that is not yet the case. That's different. For example, I was once in China and I gave a course to disciplinary justices of the People's Supreme Court. And they said, well, we have a special code for judges. And there were even 17 justices specially appointed for the disciplinary justice in applying that special code. We have nothing like that in the Netherlands. But perhaps there is a development towards that direction. Could be. Could be. And why not? Okay. Yes. Now, well, the very, very last.
Yeah. Is there any mechanism or a structural process in the Netherlands to make the judges understand and aware about these values? And is there any, for example, in Indonesia we have the Judicial Commission who supervise the behavior of the judges. Is there also specific institutional plan?
What is done is that judges and also other legal personnel working at the courts are made familiar with these values and rules in an educational program.
Is it regular or just one time?
This is it's regular, but it's limited in time. And it's, I think that in all the courts now, this educational program is enrolled, and everyone was obliged to participate. And I think it's now finished, but I'm sure that the Council for the Judiciary will start another program when they think it's necessary. So, but they try to make it familiar through the means of education.
So there is no routine internal discussion within the court to emphasize this value?
No, no. But there's a lot of informal social control. I mean, say young judges, they learn it more or less implicit when you work with experienced colleagues. If I take myself, long ago, old man, long ago when I started as a judge, I was appointed to the Court of The Hague, the first instance, and then we had a lot of collegial decision making, so you always sat with 3 judges. So you always had this example of the other judges. You could see their behavior, their ways of doing, and you could internalize it. So there was a lot of transference of knowledge and competence and experience. nowadays it is somewhat more difficult because more judges are sitting alone. The institution of the unus juris is introduced on a larger scale than the laws. And it means that this implicit transference of knowledge and expertise is reduced, diminished. It's a pity. And that's why I think that explicit courses and education have to take over and step in. Okay, this is the place of independence as core value. Now, focusing on independence, I first want to make a conceptual distinction. There are three types of independence. First, there is independence at the macro level of the institution itself, and that is the independence of the judiciary as a whole. The judiciary as a state power. I come back to this. The second level is what one could call the meso level, is the independence not of the judiciary as a whole, but the independence of specific courts, organizations. Independence, for example, vis-à-vis the Ministry of Justice, or vis-à-vis the Council for the Judiciary, or vis-à-vis the Public Prosecutor's Office, for example. And then lastly, there is at the micro level the independence of individual judges. The independence of individual judges vis-à-vis his or her colleagues, or vis-à-vis her superiors, or vis-à-vis parties, or whatever relations one can think of. But these are three different levels of independence. And I think that for debate it is very, very important that we distinguish between the three different levels. And I would like to say a few words about this macro level, the independence of the institution, the judiciary as a whole. Because that has to do, as you can imagine, with the doctrine of the separation of powers, the trias politica. Now there are all kinds of ways to define this trias politica, and I always liked the approach that was developed in the 70s by Nonet and Selznick. They wrote this wonderful small booklet. It's a classic, you know it, I see it. Law and Society in Transition. And it's a small booklet, it's a very important book. And they say, well, the separation of powers, the trias politica, is in fact a kind of trade-off. A trade-off between politics and the judiciary. Yes?
Professor, in your opinion, in one hand, the idea was to having the judicial independence, but on the other hand, there was let's say, the concept of the check and balance itself.
I'm sorry?
The check and balance principle.
Yeah.
What if, let's say, a judge be examined in the term of their judgment, or as you previously mentioned before, there was clearly infringe the code of ethics and then being brought into the highest position, their superior, but there's a tendency or arrogance to protect their fellow colleagues or jurists rather than apply the concept of several rules to several people.
Do you mind if I come back to that?
Okay.
Yeah, because this is I think this is more appropriate to deal with at the level of the micro level of the individual judges. So I would like to first say a few words about the other levels. This separation of powers, a trade-off between law and politics, and the trade-off is this. For example, they sit together and they make some kind of agreement. Of course, it's never done explicitly, but you can imagine that on the one hand, the judiciary acknowledges the primacy of politics, and on the other hand, the politicians recognize judicial autonomy. So they somehow there's not only a separation of powers, but it's also a kind of division of labor. And politics, the domain of the politics is substantial justice. The general rules about how society is to be governed. And the domain of the judiciary is something else. It's not substantial justice, but mostly it's procedural justice. And so the judiciary has quite another responsibility. It's doing justice in individual cases, not doing justice generally for society. So there's a kind of trade-off. There's a kind of, this is your domain, and that is my domain. And of course we can have borderline conflicts, whatever, we come back to that. But roughly speaking, this is how we do it. Yes?
What about independence from the social pressure? So apart from the potential influence from the executive or the parliament, what about the fact that society may put pressure on the judiciary?
I come back to that, because that's what happens. This is only the theoretical model. I come back to that. So this is, and what happens, if this is a kind of division of labor, it puts restraints on both parties. Because the restraint is that the judiciary should not interfere with too much. I'm sorry. I won't do that again. It should not interfere too much with political issues. And on the other hand, politicians should not interfere too much with judicial issues. Of course, the problems raised when we ask, what is too much? I'll come back to that. But there's some kind of division. Now here, at the major level of courts, what the situation in the Netherlands until 10 years ago was that we had 19 courts of first instances and 5 appeal courts and 1 Hoge Raad, and they were all separate islands. They were all separate, they were governed by their own president, and each president had needed public funds and got it from the Ministry of Justice. And some courts worked perfectly and other courts worked less perfectly. It were islands. There was no unity. It was an archipelago of independent islands. Independency of the courts. Now what happened in the Netherlands was it was found to be not very effective. Because some courts were efficient and effective. They were ruled effectively, and other courts were not that successful. And for example, in one court there was a lot of expertise in one field, and in the other court there was no expertise on that field. So why couldn't they work together? Why couldn't they cooperate? So that was not a very efficient way of spending public money. Money of the taxpayer. So how to improve on this? That is the measure level. Now what happened, legislation was introduced, and a council for the judiciary was introduced, and it was placed at the top of the hierarchy, and the first and foremost responsibility of the council for the judiciary was to make these organizations efficient and effective, and to rule them and govern them in the same way. And another function was to keep the Ministry of Justice at a distance. So it was not the case that each president had to negotiate with the Minister of Justice for its funding. There was the chairman of the Council for the Judiciary who did that. for all the courts. So the intention was to put something between the courts and the executive. That was what happens at the meso level. Now here we have at the micro level the independent judges. Now what is important in independence here is that individual judges have the right of free judgment. That means that they have to decide the case on the law and the facts of the case alone. Substantial justice on the one hand, procedural justice on the other hand. This was a kind of workable division of labor, and I think that most academics plead for the restoration of that traditional division. I don't know if it is wishful thinking or that we are already too far from that original position. It would, of course, be my preference too, if the two got out of each other's way more than they do now. Because I don't think that these collisions between, I think it's a real threat to the independence of the judiciary. It's a serious threat at the moment in the Netherlands. And the key question is, of course, how to countervail this threat. And I would say not to attack more fiercely even the politicians and politics, but to plead for common sense on both sides, restraint, withdrawal, and restore the old division of labor. That would be my opinion. But I don't know if it is not too late. Could be. I'm not sure. Yes?
You mentioned that recently the Netherlands legislature enacted a statute which give a penalty, a minimum penalty, which according to most judges in the Netherlands is the infringe of the independence of the judiciary. It's also the same feeling happened in Indonesia.
Yeah.
Recently many statutes provide a minimum penalty. Yeah, 52. And I think most judges feel that this is not good. So, especially in the corruption, there's a tendency from the executive that would like to provide a scheme. You know, if the prosecutor has this, a long length of imprisonment, it should be this. So this has been also debated. So my question is whether there is a case in Netherlands where a judge in delivery decisions which infringe or violate the deviate from the minimum penalty.
No, because it is
here it's common.
It is
common. That's why the executive and also the
it's not valid law yet, so there can't be an infringement yet.
I see.
It's coming on. It's coming on, and we will see. But there is some kind of escape clause in the legislation. That if the judge thinks that this penalty really is not applicable in this case, he can diverge from that, but it has to be very well motivated. Now, what happens? Of course, what is of interest is, of course, whether this clause will be used to escape in many cases the minimum punishment that the legislator has designed. We will see. We don't know yet. And in Indonesia, it has happened. It is violated.
Yeah, that's why they need unhappy of public and also, of course, executive power and legislative power. I heard that there's a plan from the executive power to make arrangement.
What one can imagine, for example, is that the criminal chamber of the Supreme Court will be more strict in the interpretation of specific legal terms. For example, we have the concept of intent, and we have the concept of conditional intent. And the Supreme Court is nowadays very lenient on conditional content. So it is easily accepted, conditional intent. But if intent, for example, intent to, with regards to the death of someone, results in a very high minimal punishment, one can imagine that the Supreme Court will be more strict in the interpretation of conditional intent. To evade, not to escape, but to evade this minimal punishment. Another example would be, you know, one can commit an act, or one can, a criminal act, or one can commit a criminal act together with another. Medeplegen. Well, the Hoge Raad has been very lenient on this concept. One can imagine that the Hoge Raad becomes more strict if it will have consequences in terms of the minimal punishments. So I think that there are all kinds of movements going on nowadays anticipating this law on minimal punishment to make it possible, when it is enacted, to evade its consequences. But what will happen at the end of the day, we will see when the act is really in place.
I'd also like to share information with you that what you mentioned, it happens in Indonesia, especially in the macro level, that what I heard, that there's always negotiation in the budget between our leaders and the Supreme Court leaders and the Parliament.
Yeah.
Because although the Indonesian Supreme Court is independent in terms of managing resources, but the budget is still depend on the decision of the Parliament. Then there's always negotiation. So I would like to ask you whether in any other country that the Supreme Court is really independent in terms of managing resources and also finance. So when they propose a budget, there is no negotiation. Like what we did in banks, Central Bank. Bank of Indonesia is really independent. So they are really independent. So what our leader now is thinking, having that kind of model like in the Indonesian Central Bank. But unluckily, the Indonesian Central Bank of Indonesia is established its independence in the, financially, and also organizationally within the constitution. But not Supreme Court is only meant independence, but what it means, it should be interpreted later.
There's an important difference there between the Indonesian Mahkamah Agung and the Nederlandse Hoge Raad, because you have the one roof system.
Yeah.
Which means that the Council for the Judiciary with us is integrated in the Mahkamah Agung. So the negotiations between the Judiciary and the Ministry of Justice are on the judicial side conducted by the Mahkamah Agung. We have a separate organ for this, which is the Council for the Judiciary. I think we can address the question which system is preferable. Personally, I think your system is preferable. But another question is, can one evade the situation that the judiciary has to negotiate with the executive for its funding, which is of course a very delicate process with regard to judicial independence, because you are independent from the executive, but at the same time you have to ask your funding,
and also in Parliament.
And also Parliament.
Not Minister of Justice, but Minister of Finance.
Minister of Finance, okay. In the Netherlands it's different. It's integrated, and the negotiations take place not with Parliament separately, but with the Ministry of Justice, and not Ministry of Finance. Well, I think it's very delicate, and I think that if we could think of another system that on the one hand makes it possible to fund the judiciary, but on the other hand and efficiently and transparently and accountable, because of course the judiciary has to be accountable for the spending of the public funds. Independence doesn't mean that you are not responsible for the spending of public money. Of course you are, as every governmental organization is.
We do have a national audit agency, so to audit all the money. But what we think is to get the, more independent about.
Could be a solution if you say, well, there's negotiations and then there's an independent third organ that audits.
Which will see the use of money.
Audits, whether it is used in accordance with law and efficiently. Yeah. Could be a solution. The algemene rekenkamer could be there. There's some institutional and some potential conflict.